All right, so we've wrapped up our discussion on the basics of contracts, what a contract is, um, how we go about forming a contract, the enforceability of certain provisions in a contract, when a contract needs to be in writing and when it doesn't, and in order to be enforceable. And then also we looked at an alternative way to recover money from somebody when they've broken a promise to you, even though it was not a contractual obligation, and that was our remedy of promissory estoppel. Now we're going to continue our discussion of contracts in the next chapter, but we're moving into a discussion about a specific type of contract and the rules that apply, namely contracts just for the sale of goods. These are movable, tangible items that you contract for. Think about the inventory in a warehouse or on a store shelf, or goods that you may purchase over the internet in a bulk supply or in individual purchases. Contracts for the sale of goods have follow the same rules that we were discussing when we talked about contracts for services. When you hire somebody to paint your house or to build to do a construction project for you, we're going to look at all those same rules, but we're going to learn how, with contracts for the sale of goods, all of those rules, for the most part, they're all modified slightly as they pertain to contracts for the sale of goods. And the goal, at least as I see it, is with contracts for the sale of goods, all these rules are going to be a little bit more lenient. They're not going to be quite as demanding and restrictive. And that, in my estimation, is really because when you're dealing with a service contract, like a construction project, we're going to expect the parties to be able to sort of negotiate those terms over a longer period of time. There's going to be more deliberation when it comes to services. But with goods, a merchant needs to be able to replace the inventory on their shelves, like that. You're not going to want to have these long deliberative negotiations when you're running out of inventory and you need to replace goods in your warehouse or on the store. So the rules make it a little bit easier for people to bind themselves into a contractual obligation when it comes to the sale of goods, without having to observe quite as many formalities and restrictions, basically. So all the rules, we're going to look at all the same rules that we looked at before, but you're going to see that they're all a little bit different. So you need to be prepared to sort of compare and contrast the two, and know, if you were asked about what it means to make an offer, a proper offer or acceptance with contracts for services, you're going to need to know what the rule is for a service contract versus what it is for a contract for the sale of goods, because they're similar rules, but they're each going to be slightly modified or slightly different from one another. So what I'm going to do here is I'm going to pull up minimize myself again, and then pull up our slideshow. Okay, the name of the chapter is Domestic and International Sales, but you can just think of the focus here being, again, just on contracts for the sale of goods. Now, as with torts and contract law generally, these rules come down to us from common law, from a series of court cases deciding these issues. Like with torts and the restatement, we have something called the Uniform Commercial Code for contracts for the sale of goods that was drafted to summarize all the rules that we've learned, that we've gotten from court cases throughout the years. And it's something that states have the option, have had the option of adopting into their own statutes. It's not mandated, but I believe all states have adopted some form of it. So in South Carolina, we have the South Carolina Commercial Code, and basically what it is, it's we've taken the UCC that was drafted, summarizing all these rules, and we've given them our own statute numbers, and each state does the same thing. And different jurisdictions might have slightly different rules, but the rules we're going to talk about are going to, I believe, pertain to across jurisdictions. Now, the Uniform Commercial Code actually contains a lot of provisions, a lot of articles that deal with different topics. We're talking about Article 2 here, which is just dealing with the sale of goods. Article 9, I believe, deals with secured transactions. Article 4, I think, deals with banking codes. And but we're just focused here on Article 2. So it's important just to keep in mind from the very beginning that what we're talking about, again, is just the sale of goods. So not the lease of goods, not the sale of services, just the sale of goods. What are goods? We've already talked about that. They're movable, tangible items. Now, there is a situation, and I mean this would occur frequently, where you have a contract that actually deals with both services and goods. So you hire somebody to build a network for your office, an inter-office computer network, and along with that service, they might sell you some of the goods that are necessary: computers, servers, network printers, and things like that. So the question then becomes, well, when you're analyzing that contract, which do you apply? Do you apply the UCC, the Uniform Commercial Code, or do you apply the rules that we learned in the last chapter for contracts for services? To answer that question, you just have to ask, what is the dominant purpose of the contract? And the example I just gave you, the dominant purpose was probably that the service of building this network, specifically for our office and for our purposes. That's really why we hired them. It wasn't because we could have gotten the goods someplace else, but we just went ahead and bought them from them as well as an incidental part of that contract. And with goods contracts, the dominant purpose may be the sale of goods, but there might also be some service attached to it, like the delivery, for instance. The shipping and delivery is a service that the seller might provide. But the real reason you're contracting with them is because they've got the goods that you want. So in that case, you're going to apply the UCC rules. In the UCC, there are some rules that apply just to merchants, people who deal regularly in the type of business that's involved. So a car dealer versus somebody who's just someone like me who's just selling their car as a one-off sort of thing. And this is because a merchant, somebody who regularly works in a certain field, has a certain level of sophistication in that area, and we can and business expertise, and we can expect to place greater responsibility on them when it comes to holding them to some of these rules. Again, it applies to the sale of goods. For testing purposes, I don't really try to trip anybody up about that, but it's just worth keeping in mind. It would not apply to a lease article. The UCC does cover leases, but that's Article 2, Section A that deals with that, and that's not what we're looking at. Book talks a little bit about transferring title. I don't go too much in that with questions because generally it's going to be pretty clear when the title is transferred to the purchaser. So from there, I want to get into our first set of rules that differ, going back to the beginning of contract formation, and again, those elements that it takes to form a contract. There's 3 of them, remember: offer, acceptance, and consideration. So I want to go back to the beginning there and start with the offer. Now, this is a page that's taken from the book that compares and contrasts the offer and acceptance in the UCC versus the rules that we learned before. Now, you'll see at the top there in the top left, looking at the offer, it says the common law, which you'll see that phrase to contrast with the UCC. Common law is what we're referring to when we're talking about service contracts, and the UCC, or the commercial code, is what we're talking about with goods contracts. So it says the common law requires that the terms and conditions of A's offer be reasonably detailed, and an offer with unclear or missing terms and conditions can't serve as the basis for a contract. So in the previous chapter with some of the examples, if I had said that I would mow your lawn, and you said, okay, I accept that, but if we had not agreed, by the time we had a dispute, if we had not agreed to the price or whatever the consideration would be, maybe it wouldn't be a price, maybe it would be that you would trade me something to mow the lawn. But if we hadn't decided that yet, then we don't have a clear, or if the offer hadn't specified what I wanted in exchange for mowing the lawn, then we wouldn't have an offer that could reasonably be turned into a contract. And of course, we wouldn't, even if it was accepted, we wouldn't have consideration there. So what the offerer is expecting in exchange for this has to be, all put out there on the table in order for us to form a service-based contract. Now, if you go down, follow the arrow down there to the UCC, where the highlighted words are, it says, as to A's offer, the UCC is less demanding than the common law, and if B intended to enter into a binding agreement, the person who's accepting the offer, a contract will exist even if some of the offer's terms are omitted or left open. So they may simply be not there at all. So you could have we'll look at a case later where they agree to, it's a contract for the purchase and sale of trout fish, and they say the trade is going to happen when the fish have been grown to market size. Now, the term there is not omitted, but it's certainly not clear, and under the common law, that wouldn't be valid. We wouldn't have a complete contract at that point because there's still work to be done. They still have to negotiate what that is going to mean. But under the UCC, as long as the parties intend to enter into an agreement on that basis, then it's fine that's ambiguous to somebody looking at it from the outside. They can figure that out later. They've agreed to market size, and then what that is, we'll see. The UCC will tell us how to go about analyzing different elements when they're missing or they're left open or ambiguous. So there's a provision in the UCC that'll say, what do you do when, say, the price is missing? Also, the term could be simply omitted, like the price, for instance. As long as you've agreed to purchase something, the UCC is going to has a provision that expects people to buy and sell for a reasonable price given the market value of whatever's being exchanged, but you can leave it open and still have a valid contract. And so what's important is that if you go to back out of the contract, you're not going to be able to say, if it's a goods contract, well, we hadn't determined exactly what the price is going to be. A court will expect you to go through with it, and you're going to have to pay a reasonable price. And we'll look a little bit about how we determine that later. Parole evidence is going to become relevant to that, where we might have to have outside discussions brought in as evidence because the writing itself is not enough to explain what is meant by a fair market price or what is meant by market size in the case of the trout in the trout case that we'll talk about later. Then we move over to the acceptance, and you'll remember this at the top there, top right. It says the common law requires that B's acceptance be unconditional, definite, and legally communicated, and if one of these requirements is missing or changed, a binding agreement is not created. The main thing that's really getting at there is the rule that if somebody comes to accept my offer and they add a new condition to it, that terminates the offer, and I haven't accepted it. What I've done is made a counteroffer. And so now the ball goes into the other guy's court, and he becomes the person who has to accept it. Under the UCC, it says as to B's acceptance, the UCC is more flexible than the common law, and the UCC allows B to add or change terms. And if it's accepted and validly communicated, and the intention is there to be bound into a contract, we will have a contract even if there's been a new condition added to the acceptance. So it does not, under the UCC, turn it into a counteroffer. So you could say, I accept that, but on this additional condition, and as long as the intent is there and the consideration is there, we have a valid contract, and it has not terminated the original offer and turned into a counteroffer. And what we do with that extra condition, whether it becomes part of the overall contract, we have a special rule for dealing with that, and I'll come back to that in a little later. But again, as you can see from the beginning here, when we talk about just the basics of forming these, the rules are less rigid, and they're made that way to make it, because goods, people contracting for the sale of goods are probably going to be making much swifter agreements. It's going to be maybe a phone call or an email that says, we need this many items on the shelf. Can you provide them? Yes, we can provide them. Sign this purchase agreement, and then we'll get them to you the next day. And so that's part of the reason we need less rigid rules. We don't want people to be able to back out of a contract because some term was not completely fleshed out, or some new condition was added at the time of the acceptance. We want to hold them to that as long as they were, as long as the intent was there to be contractually bound. Okay, and I'm going to leave it there, and then we'll start off looking at some of the some more of the rules that pertain to these and how they differ from the common law rules for service contracts.